Can lemonade kill you? Is Panera selling deadly poison? Well, one lawsuit alleges that's the case. The parents of a student who died after drinking Panera Bread's charged lemonade have sued the company for wrongful death. According to the lawsuit, Sarah Katz died of cardiac arrest after drinking a 30-ounce cup of the lemonade, which contains more caffeine than a can of Red Bull and Monster energy drinks combined, plus 30 teaspoons of sugar. Panera allegedly did not advertise lemonade as an energy drink in its stores.
This is a charged lemonade from Panera, and it's a force of nature. A delicious boost of plant-based caffeine from guarana and creamy coffee extract. Enjoy these and more when you join Panera's Unlimited Sip Club.
Sarah Katz wasn't the only customer taken by surprise at the ingredients in the drinks. It's taken TikTok by storm. TikTokers have been posting about charged lemonade for over 2 years. In December, Sarah Baus shared a TikTok video captioned, "This drink should come with a warning because it's delicious and will lead to my cardiac arrest."
This, the regular size has 82 grams of sugar, grams of sugar. It has 260 milligrams of caffeine. An espresso, I looked it up, has 63 milligrams of caffeine. And I feel like the Hulk.
Baus only discovered what was in the beverage later on when she was going to order the drink for her husband, who has type 1 diabetes. The nutritional facts were available on Panera's website. Her video went viral, prompting Twitter user FindGodMother to share the video on Twitter, where it was captioned, "Somebody at Panera Bread gonna end up getting sued." Another TikToker loved the drink and said that she was drinking one every 2 hours, but like Baus, she didn't realize the drink had so much caffeine until later.
I just found out that it literally has almost 400 milligrams of caffeine. So please drink at your own risk. If you have any restrictions to caffeine, please be careful.
And as you can see, the first comments on the post, which were made in 2022, also note the extremely high caffeine content. "This drink gave me pre-workout level jitters. I wish they didn't have caffeine because nobody needs 400 milligrams. It's just too much." Now, I don't have a heart condition, so I had to try this stuff for myself. This is the strawberry lime, and it's, yeah. I mean, it kind of tastes like lemonade. It definitely doesn't taste like something that contains a boatload of caffeine. And if I hadn't seen the warnings beforehand, I probably would not assume that this is a highly caffeinated drink. And oddly, it doesn't taste particularly sweet. I definitely would not have assumed that this contains way more sugar than the equivalent size of regular Coca-Cola. Yeah, honestly, I'm getting more of the sour from the lemon or the lime than I am from the sweetness of the sugar or whatever caffeine tastes like. And on top of that, it really doesn't taste like an energy drink. It tastes kind of like a flavored lemonade. So what happened in this wrongful death case? Well, Sarah Katz was a 21-year-old University of Pennsylvania student who passed away in September 2022 after consuming a large cup of charged lemonade from Panera Bread. Sarah went into cardiac arrest after drinking the lemonade at a Philadelphia Panera Bread location, and despite being taken into a nearby hospital, she suffered a second cardiac arrest and did not survive. She had recently purchased an unlimited Sip Club membership from Panera, allowing for free drink refills, and had consumed at least one charged lemonade in the days leading up to her death. Sarah was diagnosed with long QT syndrome at the age of 5, a heart condition that led to abnormal heart rhythms during stress or exercise. She managed this condition through medication, regular medical checkups, and by limiting her caffeine intake. It's alleged that Sarah was up to date on the latest research about her condition. She was a research assistant at a children's hospital and frequently participated in research studies to maintain her and others' conditions without incident. The medical examiner listed her death as cardiac arrhythmia resulting from long QT syndrome. The medical examiner did not mention the caffeinated lemonade as a contributing factor. The report concludes that she had no other drugs in her system except for what the hospital used to revive her. And after her death, Sarah's parents filed a wrongful death lawsuit alleging that the Panera charged lemonade is a dangerous energy drink. Now, since the lawsuit was filed, Panera has dropped the amount of caffeine in their charged lemonade drinks. A large, which previously contained 390 milligrams of caffeine, now clocks in at a mere 230 milligrams of caffeine, which is a 40% reduction. So according to the complaint, this means that a 30-ounce cup of Panera's charged lemonade quote, exceeds the combined content of 12 fluid ounces of Red Bull, 114 milligrams of caffeine, and 16 fluid ounces of Monster energy drink, 160 milligrams of caffeine. And the complaint goes on to allege that, quote, the sugar content of Panera's charged lemonade ranges from 82 grams to 124 grams of sugar, exceeding the combined contents of both a 12 fluid ounce Red Bull, 27 grams of sugar, and 16 fluid ounce Monster energy drink, 54 grams of sugar. The drink contains other known stimulants such as guarana extract, which increase the stimulative effect of the beverage even more, And because these ingredients, the Katz family contends that the drink is not lemonade at all. It's actually an energy drink with lemon flavor. And despite these ingredients, the lawsuit alleges that Panera does not market the charged lemonade as an energy drink. Quote, Panera Charged Lemonade is a juice beverage marketed to children and adults alike, and it was displayed and offered in Panera stores in the same or similar manner and location in which they offer other non-caffeinated juice beverages. And you can tell to this day that Panera continues to market their charged lemonade online. It's apparently still their flagship beverage. If you look at the drinks section on their website, it's the first thing that they show before Coke and other sodas. And you have to scroll even farther down to find tea and lemonade drinks that won't give you heart palpitations. Now, the Food and Drug Administration, or the FDA, says that you shouldn't consume more than 400 milligrams of caffeine per day, and that's just about one large serving of charged lemonade. The beverage was available as part of Panera's Sip Club, meaning consumers could get unlimited refills. And according to the complaint, Panera Charged Lemonade is advertised as plant-based and clean with as much caffeine as our dark roast coffee in small print and suggests sip, enjoy, repeat, unlimited Sip Club. But it also seems like one 30-ounce cup of charged lemonade contains about as much caffeine as 3 to 4 cups of regular coffee. This picture shows the lemonade next to the coffee and juice drinks, but it had way more caffeine than either of those drinks. It's alleged that Sarah was cautious about her caffeine consumption due to her heart condition and had been advised by her doctor to avoid highly caffeinated beverages and energy drinks. Sarah's roommate, Victoria Conroy, told NBC News that Sarah was, quote, very, very vigilant about what she needed to do to keep herself safe. I guarantee if Sarah had known how much caffeine this was, she never would have touched it with a 10-foot pole. The Katz family believes that Sarah thought the drink was more akin to a sports electrolyte drink or a regular lemonade with a relatively safe caffeine content. The lawsuit alleges that Sarah would not have consumed it if she had known the true caffeine content. Sarah consumed electrolyte drinks like Gatorade, and the lawsuit suggests that Panera marketed charged lemonade as an electrolyte drink. And the lawsuit alleges a similarity in iconography between the Gatorade logo and the fact that they called this a charged lemonade. And the complaint includes several pictures showing how the charged lemonade was advertised. It was, quote, offered side by side with all of Panera's non-caffeinated and or less caffeinated drinks. It was not advertised as an energy drink. And at the time, the Panera Bread menu did not include a warning of any risks of ingesting these concentrated amounts of caffeine in connection with the stimulants and sugar. And now the Panera website advertises the charged lemonade as the ultimate energy drink. Quote, the new Panera charged lemonades are the ultimate energy drink guaranteed to charge up your day, powered by clean caffeine from guarana and green coffee extract. These caffeinated lemonades feature refreshing mango, cranberry, or strawberry mint flavors. These drinks are cold, caffeinated, and so ready for summer, plant-based and clean with as much caffeine as our dark roast coffee. Of course, this is all what Panera says online. The caffeinated nature of the drink might not have been advertised in that way in store at the time of Sarah's death. Now, if you've ever suffered any food-related damages, you'll need a great lawyer, and my firm, the Eagle Team, can help. If you've had an injury or death in the family, suffered a data breach, or were involved in a car crash, we can represent you or help find you the right attorney who can. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. The link is down below. So based on these factual allegations, the complaint alleges several different legal theories. Product liability law recognizes several different theories that could lead to recovery. Generally, these theories are not mutually exclusive, which is why the family has sued Panera for defective design, defective manufacturing, and failure to warn. Count 1 is for strict liability. A strict liability tort is a type of personal injury case in which someone is held liable regardless of whether they were negligent or not, usually for a defect in a product. A defendant is liable when a plaintiff proves that a product is defective regardless of the defendant's intent, and it's irrelevant whether the manufacturer or the supplier exercised great care. If there is a defect in the product that causes harm, the defendant will be liable. And then there's the defect in design claim. The Katz family claims that Panera had a duty in strict liability to design and manufacture drinks for consumption without a defective condition and to warn about the dangers inherent in the drink. They allege that the company knew or should have known of the foreseeable risk of cardiac-related injuries inherent in the design and manufacturing of Panera charged lemonade. A design defect exists when a product is built in accordance with its intended specifications, but the design itself is inherently defective or poses unreasonable dangers to consumers. And the complaint outlines 24 ways the product was defective, such as the website allegedly misrepresenting the beverage's caffeine content as, quote, as much caffeine as their dark roast coffee, when a large Panera dark roast coffee contains only 268 milligrams of caffeine, and a large Panera charged lemonade has 390 milligrams of caffeine. And the complaint alleges that Panera failed to warn consumers about the potential risks that may occur when the drink is consumed. In strict liability law, inadequate or non-existent warnings are considered a type of product defect. However, manufacturers only have an obligation to warn consumers of risks that are not considered obvious. For example, a manufacturer of scissors would probably not have to warn consumers that the scissors are sharp because that's the explicit purpose of the product. However, if the manufacturer of a painkiller knew it could cause cardiac arrest, it would have a duty to warn the public, since cardiovascular events are not an obvious result of the use of that kind of medication. So for example, when Merck introduced the painkiller Vioxx, it withheld information about the serious risk of heart attack and stroke from doctors and patients for over 5 years. And up to 140,000 serious cases of heart disease were linked to Vioxx, and the company withdrew Vioxx from the market. So here, the complaint alleges that Panera did not provide adequate information to the public because it, quote, misrepresented the beverage as a fruit juice and/or non-caffeinated beverage, and the marketing did not indicate it was an energy and/or highly caffeinated drink. The company, quote, did not explain its potential to cause cardiac-related injuries, especially in children, pregnant and breastfeeding women, and caffeine-sensitive individuals. Panera also, quote, marketed the Panera Charged Lemonade as safe and plant-based, but did not advertise or otherwise disclose the amount of caffeine in their Panera Charged Lemonade. Now, we can't go back in time to see what the signage and warnings looked like in 2022, but here's what it looks like in present day. Panera has a clear warning on the tablet when you order this particular lemonade, and it's no longer out in the open for anyone to pour themselves, and especially to get free refills. You have to ask at the counter. Now, other companies have been sued for misrepresenting their ingredients in their beverages. The company behind Four Loko, a caffeinated alcohol beverage, settled a wrongful death lawsuit in 2014. Four Loko was sold in an unusually large package size and had high levels of both alcohol and caffeine. The company appeared to be marketing the drink to college students who were interested in binge drinking. And one of the drink slogans was blackout in a can. The parents of a 23-year-old college student sued after their son drank 2 cans of Four Loko and then ended up in a confrontation with police in which the police shot and killed him. A judge ruled that the defendant was not immune from liability, and Four Loko agreed to pay $400,000. The Federal Trade Commission also investigated Four Loko, ordering the company to make changes to its labeling and marketing. The FTC had alleged that the ads for Four Loko falsely claimed that a 23.5-ounce can contained the equivalent of 1 or 2 cans of beer. In reality, each can contained more like 4 or 5 beers. The Katz family complaint alleges the drink was similarly defective in its marketing, manufacturing, and labeling. Panera Bread, quote, knew there was a high degree of probability of harm to decedents and acted with reckless indifference to the potential and foreseeable consequences of the defendant's defective product. And based on the same factual allegations, the complaint also alleges counts for negligence, misrepresentation, and breach of express warranty. To date, Panera has yet to file a formal response to the lawsuit. The company issued a statement, quote, we were saddened to learn this week about the tragic passing of Sarah Katz. While our investigation is ongoing, out of an abundance of caution, we've enhanced our existing caffeine disclosure for these beverages at our bakery cafes, on our website, and on the Panera app. Panera has also posted new disclosures about the drink, quote, naturally flavored, plant-based, with about as much caffeine as our dark roast coffee, use in moderation, not recommended for children, people sensitive to caffeine, pregnant or nursing women. Please note this beverage is self-serve upon pickup. And the US Food and Drug Administration has announced it is investigating the case, and some Panera locations have moved the drink behind the counter. Now, when a person files a lawsuit alleging that they were injured because of someone else's negligence or recklessness, the victim has to prove that the other party owed them a duty, that he or she has breached the duty, and that the breach of duty caused the injury, and that the victim suffered damages. Now, the Katz family alleges that Panera breached its duty and Sarah died because she had a rare heart condition, but as far as we know, no one else has been injured or died from drinking charged lemonade. So for the purposes of liability, does it matter that Sarah suffered injuries because of an underlying condition that the average person doesn't have? Well, generally, a defendant is responsible for all of the injuries caused by their actions, regardless of the unforeseeable or uncommon nature of the plaintiff's reactions to those actions. This, as every first-year law student knows, is known as the eggshell plaintiff rule, and it encompasses 2 main types of unusual plaintiffs, the eggshell plaintiff and the plaintiff with pre-existing conditions. Now, some people might be able to withstand minor injuries without significant harm, and others might be more susceptible due to unique conditions. Let's say there's a car accident where one car rear ends another car and the 2 people in the back seat are injured. Person 1 comes out of it with minor scrapes, whereas person 2 sustains a skull fracture because of a unique condition where they have brittle bones. And this is where the eggshell part of this the legal idea comes from. Now, the eggshell plaintiff rule dictates that if the plaintiff with the fragile skull sustains an injury due to another person's negligence, the responsible party becomes liable for all of the resulting damages. And although the defendant is obligated to accept the plaintiff as they are and pay for all damages caused by the breach, the defendant is not required to exhibit a higher duty of care specifically tailored to that eggshell plaintiff. So in this case, it probably means that Panera Bread isn't required to assume that every person has long QT syndrome. If the company had to assume a higher duty of care, then they probably wouldn't even sell drinks at all, let alone a drink with that much caffeine. But that's not the rule. Panera's liability in negligence is contingent on a breach of the ordinary standard of care, irrespective of the plaintiff's particular vulnerabilities. Now, you're probably wondering, what is long QT syndrome? Well, for that, I turn to the internet's doctor, Dr. Mike. So Dr. Mike, what is long QT syndrome?
To understand long QT syndrome, Devin, we need to start first by talking about what the heart is. And the heart is a muscle, but it's different than the muscle that moves your bones. That's called skeletal muscle. Cardiac muscle has little ion channels in it that allow the flow of ions like calcium, potassium, sodium, etc. Now, those who have long QT syndrome actually have disruptions in those ion channels where they don't exist or they don't work properly, specifically in the lower portion of the heart known as the ventricles. Now, when this happens, that can cause the heart to go into a dangerous rhythm or maybe even lead the heart to stop completely. This doesn't happen to everyone who has long QT syndrome, but it is a major risk. In fact, 1 out of 10 people find out they have long QT syndrome after they have a cardiac arrest and their heart stops or they suddenly die. So it can be a very devastating condition. And it also matters whether or not you were born with long QT syndrome or you've developed it due to a number of diseases or possibly even medications that you might be on.
And how does caffeine affect someone that has long QT syndrome?
Well, when we think about caffeine, we know that caffeine increases cardiac output. It actually puts a little bit of strain on the heart. And for someone who's healthy and has no cardiac problems and is taking a moderate or normal amount of caffeine, that shouldn't be a problem. Now, if someone has long QT syndrome, that does put them at a higher risk for developing problems with caffeine. This is why the American Heart Association, among other organizations, will go out of their way and urge caution, especially to young folks with long QT syndrome, about consuming caffeine at all. It is considered a risk factor. Remember, caffeine doesn't only put a strain on your heart, it could also put a strain on your kidneys and blood pressure so that your heart has to pump against a higher pressure.
Could 390 milligrams of caffeine cause someone with long QT syndrome to have a cardiac arrest?
Could it? Yes. A lot of things could cause cardiac arrest in a person with long QT syndrome. Now, usually, and as in most cases, things are multifactorial, meaning that multiple things happen at the same time in order for an event like a cardiac arrest to occur. That being said, consuming a high amount of caffeine, almost 400 milligrams of caffeine, is at the top end of what's recommended daily for an adult. But now if you have long QT syndrome, your heart might be more sensitive. So is there a world where this medication caused that person to go over the edge and then develop cardiac arrest? It's absolutely possible. If you're having more than one, where you're getting into a place where you're having over 400 milligrams of caffeine, that can put a regular person in trouble, developing palpitations and all sorts of cardiac abnormalities.
And there are reports that people often had 4 or more drinks in one sitting, potentially more than 1,500 milligrams of caffeine. Is that bad for someone with or without long QT syndrome?
Yes. I mean, that's bad for a regular person, long QT person, even worse, obviously. But this is the era that we currently live in. And while it's bad for your cardiac system, your kidney system, it's also problematic for our sleep. And that's where most people forget about. And that's the part most people forget about when they think about the risk of caffeine. Caffeine takes hours to break down. The half-life of caffeine is actually 6 hours. Half-life meaning the amount of time it takes to go from 10 milligrams of caffeine to 5 is 6 hours. So if you're trying to get to the gym and you take a pre-workout with 1,000 milligrams of caffeine at 7, 8 p.m., that's still going to be in your body. For those people that swear they can fall asleep no matter how much caffeine they drink, I believe you. But your sleep will not be as restorative. What happens is you don't go through the proper stages of sleep when you have that much caffeine still in your system. In fact, one of the reasons patients describe daytime grogginess is because of poor sleep hygiene, usually coming as a result of caffeine intake after 5 p.m.
Thanks, Dr. Mike. Definitely check out Dr. Mike's channel and check out the collaboration we just did where we both reviewed the first episode of Law & Order that involves medical malpractice. We had a really good time filming that.
All right, Devin, thank you so much. As always, stay happy and healthy.
Now, if you'd like a great meal from people that have never put potentially deadly amounts of caffeine in their drinks, I'd recommend today's sponsor, Factor. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat in just 2 minutes. You can eliminate the hours it would take to shop, meal prep, and cook, so you can spend your day doing the things that you actually want to do. If you're too busy with holiday plans to cook but want to make sure that you're eating well, you can with Factor. You can skip the extra trip to the grocery store and the chopping, prepping, and cleaning up too, while still getting the flavor and nutritional quality that you need. Factor meals arrive pre-prepared and ready to eat in just 2 minutes. In the same amount of time that I can even think about going to the grocery store, my Factor meal is already done. And sometimes I just want a good, healthy meal without having to cook. And it's surprisingly affordable. And now Factor offers Gourmet Plus meals as part of your weekly options, which means you can get a little gourmet with your meal plan when you're craving something special. Gourmet meals like Surf and Turf or Surf and Surf, which is shrimp and salmon, and you can relish the best of autumn and winter flavors. They really are extremely delicious, like bruschetta shrimp risotto, green goddess chicken, and grilled steakhouse filet mignon, ready in just 2 minutes. And their menus are updated weekly with 34 different options. You can choose your favorite meals or let Factor craft your order based on your taste preferences and meal history. So give Factor a try by heading to factor75.com and use the code LegalEagle50 to get 50% off your first Factor box. Or just click on the link that's on screen right now or down in the description and use the code LegalEagle50 to get 50% off your first Factor box. After that, click on this box over here for more Legal Eagle, or I'll see you in court.